This afternoon, we plan to take you on a whirlwind tour of some interesting aspects of Canadian litigation, hoping that that might help you navigate the Canadian legal system. Well, at least the common law province. Of course, the civil law system in Quebec raises a whole host of different issues, and even Canadian lawyers require a Quebec guide to navigate that system. So we'll speak to the common law system. Start with venue. Well, many might think that the most pressing jurisdictional issues in Canada relate to hockey and beer. If you are going to have litigation in Canada, you are going to need to know something about choice of venue. The fact is that there are very few choice of venue issues related to whether you should be in a federal or a provincial court. If your matter relates to something uniquely within the jurisdiction of the federal government pursuant to the Canadian Constitution, immigration, tax, intellectual property, to name a few, then you're in the federal court. Otherwise, all other civil claims are in the provincial court. So that's actually a fairly simple call to make. It gets a little trickier when you move to the question of choice of venue between provinces, when you have extra-provincial defendants, for instance. But those disputes are mainly resolved on the basis of a substantial connection, a real and substantial connection test. If you're talking about venue within a province, the rules differ across the country, but in Ontario, where I practice, the fact is that the plaintiff can bring the action in the county of its choosing. There doesn't need to be any particular connection to that county. Of course, defendants can move to change the venue of an action or a trial if it's in the interest of justice, but that's a pretty high threshold to meet on the case law.
Jury trials are very rare in Canada in civil cases, and I've probably done more than 100 civil trials. Of those, 2 were civil jury trials. And you say, well, Jim, you probably just haven't done many civil jury trials. I'm actually considered the dean of civil jury trials in British Columbia because I've actually done 2. That being said, there is a right to civil jury trials in certain circumstances. Libel and slander is really the area where that occurs. But even in those cases, most trials go forward on the basis of a judge-alone trial. Now, we do have civil jury trials in British Columbia, where I'm from. There are 10 members. They can be reduced to 8 to get a unanimous verdict. Other than that, it's a hung jury.
On to discovery. I think this is probably the most surprising news to U.S. litigators. In Canada, you only get 1 representative from the company to be deposed. We call it being examined for discovery, but it's the same thing. This individual has a duty to inform themselves of the relevant facts and circumstances, but to the extent that a relevant question is asked and the representative doesn't know the answer, then counsel has an obligation to undertake to find that information from knowledgeable persons and provide it to the other side. This is what we call the dreaded undertakings. And if you have never had the experience of being involved in compiling answers to undertakings, you won't know why we call them dreaded. They are voluminous, they are excruciatingly detailed, and they involve an extraordinary amount of work on the part of counsel. That's the bad news. The good news is it is the trade-off for having dozens or hundreds of depositions, and counsel does, at the end of the day, have more control over the evidence that is provided to the other side through the discovery process. The other thing that's a little bit different is that you are not entitled as of right to third-party discovery, whether documentary or oral discovery in Canada. You actually need leave of the court before you can get discovery from a third party. And that leave is actually granted very sparingly. This is also important if you need to get discovery evidence for use in U.S. litigation, so you don't even have to have Canadian litigation to be faced with the problem of getting third-party discovery. In order to get third-party discovery for use in U.S. litigation, you have 6 requirements. The evidence has to be relevant, necessary, not otherwise obtainable, identified with reasonable specificity. It can't create an undue burden on the third party, and that burden is always considered compared to what a third party's obligations in Canada would be, which are virtually none. And of course, the order can't be contrary to public policy.
Contingency fees have had an interesting history in Canada. In some parts of the country, like British Columbia, we've had contingency fees since the 1970s. We're very comfortable with them. We've had them a long time. They're well established. Other parts of the country, like Ontario, they've only came in 2002, and really by statute in 2004. And so they're much more controversial in some parts of the country and much more really comfortable in other parts of the country. With contingency fee agreements, they are considered to be private contracts between counsel and the client. The only circumstances that we require public approval or court approval of them is where there's a disability, where there's a minor, or in class actions where we require that all class action agreements for the funding of counsel be approved by a court. There is no Daubert standard in Canada. Our standard for expert witnesses is very low. It is someone who is considered by the court to be sufficiently skilled in an area to provide the court with assistance with their opinion. As a result, we don't really have pre-trial challenges to witnesses. The witness gets up on the stand. They are led through their expertise or their alleged expertise. They're cross-examined on that, and then there's the objection to that witness being tendered occurs at that time. There is some limited pre-trial meetings of experts that is possible. We can do that in British Columbia, but the reality is it is so limited that really it has come down to counsel believing that all you're doing is giving an idea of what your cross-examination is going to be rather than getting any useful information out of the expert, and it's not very well used, certainly in British Columbia, and I don't think in Ontario.
Yeah. As in the U.S., our clients are often faced with multiple proceedings within a province or even in several or all provinces. But unlike in the U.S., we do not have a structure equipped to manage multi-district litigation, even within a single province. Although there are some limited tools such as joinder or of claims or parties, hearing together or consolidation of actions, we really have very weak management tools to deal with multiple litigation. As a result, we mostly see multiple claims being brought in the form of a proposed class proceeding. And you may already know that class proceedings are more readily certified in Canada, and some have observed that it may be this very lack of a multi-district procedure as an alternative to the class proceeding that from a practical perspective actually drives that low threshold. Because if a judge is deciding whether hundreds of claims should be certified for a class proceeding, the only other real option is that you have hundreds of individual actions. So you do the math.
In most jurisdictions in Canada, attorney fees are recoverable. It varies from province to province as to how that is done. In British Columbia, we have a tariff system as part of our rules that sets out specifically what each aspect of the case will permit on costs. That generally gives a successful party about 20 to 25% of their legal expense in the litigation. Obviously, in some complex cases, it becomes a lesser amount, or in some cases where the disbursements are recovered, it becomes a more significant amount than that. In Ontario, they have quite a different system where they look at the actual fees that were charged and tend to then determine an amount that is appropriate for the counsel for the successful party. Interestingly enough, we have a jurisdictional debate going on with class actions, because in British Columbia there is no recovery of attorney fees in class actions. That is seen as a policy decision based upon the fact that a single claimant ought not to be responsible for a class's costs if they are unsuccessful. In Ontario, which is the other province where we see a lot of class actions, the exact opposite is true. The class proceedings can lead to awards of damage, or excuse me, awards of costs for the successful party. Practically what we've seen is that plaintiffs get generous awards for costs and defendants get very small awards for costs, but costs are available in Ontario, and it is something that varies from jurisdiction to jurisdiction.
So for many years, it has been a well-established principle in Canadian law that an expert's duty is to the court, and that duty to the court to be fair and impartial overrides any duty they may have to the party who retained them in the litigation. But in response to a concern that there was an increasing problem of opinions for sale and hired gun experts, many province rule committees have made amendments to the rules to codify this principle that was more of a common law principle. And that wasn't so disturbing because we all knew that was the rule before they wrote it down and put it in the rules. But very recently in Ontario, a judge interpreted the new rule to mean that counsel could not review and comment on expert draft reports. Yeah. As you can imagine, that decision caused an outcry. The decision is going to be appealed. Almost every important advocacy group in Ontario has sought leave to intervene in that appeal and has been granted leave to intervene. The appeal is going to be heard in September, so stay tuned. But at the moment, we're all being very, very careful about the way we deal with our experts in light of this bad but present decision.
A very recent case that actually just came out in June of this year has shown that while Canadians tend to be a modest people, we are willing to grasp out beyond our borders where we think circumstances warrant. And this is a case involving Google. What happened is a high-tech company in British Columbia brought an action against a defendant who had a questionable location. They were claiming that the defendant was breaching patents all around the world, and they obtained an injunction to stop them doing that. There was a real question as to whether or not they had stopped doing that as they were advertising on Google. An injunction was brought against Google to stop them from publicizing this company anywhere in the world, and that court order was granted on June 13th of this year. Quite a surprise, because Canadians tend not to judiciate outside the borders of the country, but in this circumstances where there was legitimate claims seen by the high-tech company and where there did appear to be a breach of a British Columbia injunction, the court was willing to enjoin Google from advertising this company on any of its web pages anywhere in the world. A leave to appeal application was heard on July 22nd, and reasons were granted. The court held, yes, that there was an appealable issue here, so Google can come in and appeal that. Google also asked for an interim stay of the order, saying, look, we should not be required to police the internet with regards to people advertising on various Google pages vis-a-vis this defendant company. And the British Columbia Court of Appeals said, no, while you have an arguable appeal, there is clearly prejudice being suffered by the plaintiff here. There's been a breach of the injunction, and we're going to enforce our injunction. And if that has an extra-provincial or an extra-jurisdictional effect across the world for you, Google, that's unfortunate, but that's the way it is. So right now we have Canadian courts perhaps following their American brethren in taking extra jurisdictional steps and enforcing injunctions, and as I said, this is quite unique in British Columbia history.
So we thought we'd close with a few unique and random customs related to the formality of our court process, so you won't be caught off guard or think you've landed in BBC programming. We wear robes to court, but not the wigs. We actually refer to our opponent in open court as my friend suggests, etc. We bow to the judge. But don't worry, it is a democracy. They bow back. Now, this is probably the most ludicrous, and it is, in fact, on its way out. But in some courts, we still have to address judges as my lord or my lady. Well, we hope that that gives you some context for the Canadian legal system, and enjoy your lunch.